okayfm 101.7.
Now, Mammy Comrade, why? Mesa Banche, yeah, Dinkobo. Okay, 101.7. So, Honorable Inusah Fuseini, a former MP for Tamale, where you Mrenimini Kese, Tamale Central, Tamale Central. Naya, you name dear, what's that, dear? Now we teach a Yama Panti, do not have any teacher Inusah. Honorable teacher Inusah, Memoachi. Pan also, nice one. Papa, and 3 days ago, you said committee almost suspended Chief Justice. No, one more the mean some report na koma mampani. And no, mampani agina so at the unity. Na minim say commentaries I would walk and na air banom near the idea. The minimum cross say the report no near ma one more establish the premier facie against my men who are one more so. I can't say why but it's so flimsy and too flimsy to be you say you bet me a it be there what from what the law is the law and come here to say
I think that idea the SC NRA is the end of an era for judicial impunity. So judicial officers, particularly justices of the Superior Court of Judicature and chairman of regional tribunal. In there, Omonim say Article 146. There's a breath of new life in Article 146. Into impunity, judicial impunity, intimate civil, abuse of office or abuse of power, and babule. Omonim say
law. Why kakra again na ebema maame actions no per article 146 no aye impunity and aye abuse of power wabra yenum se maame ni betu kwan bia no judicial service no na wobehwe niema wodo a se maame no de tu kwan na mane ho akade emusika ne other courtesies.
Judicial service no a disciplinary service. The Chief Justice Ankasa or a disciplinary officer. But constitutional internal processes. They are disciplining judges. Constitutional doesn't concern itself with that. Constitutional concerns itself with a removal process. In the constitutional as circumscribed, actually, a dear everything I see, ma omunyi justice of the Superior Court of Judicature and chairman of regional tribunal, AD. And that's what we're talking about here. And the power to do that starts with a petition by a citizen of this country to the head of state of the country, alleging justice of the Superior Court of Judicature, they are in the view of the petitioner after Article 1461. Very important. Until the argument, even the Chief Justice, the former Chief Justice, appeared before the committee to defend herself. And if you look at the processes, the fidelity to the law, you will see clearly, say, in the process, there has been a conscious, deliberate effort to breathe life into Article 146 of the Constitution.
Papa, Obi Bisa said, where did the Chief Justice err? Ebra, ya can say, wajisi kabi, ni say ogie. Ebi mo argument ni say in the worst scenario no kwa say nankle ye man refund this canon back to the coffers of state.
When I hear that argument, no, number three. Minia. Who okayfm. Now what disika? Now management of okayfm see refund the sikano. It just say sika de would di and wouldn't need quite say would this ask. Yes, sir. Yeah, that's the meaning. That's a surcharge. That means Sikano would deal with the Sikano with that recourse to the procedure improperly.
Anna, but when judiciary no, I'm Fabi, be a master. Okay.
You are even arguing double agony.
Okay.
We are Chief Justice. Now, what the Sika? Now, judiciary no says Sikano one fuck coin so end this Sikano until refund Sikano. That could be a ground for your removal. Say, would refund Sikano poor. That would be a ground for your removal. And then that's one misconduct. That's what it means.
But says he can say judiciary no also na demand.
No. Say judiciary na demand. Now we ji. One a beneficial one beneficial enjoyment of the money.
Me.
So almost say refund. Say judiciary no refund Sikano from the Chief Justice. Say refund Sikano from the coffers of the judiciary. The person who spent the money must refund the money. And at the argument they me and say who put you in a position where you will be asked to refund money, where you will say charge for the money. It's miseria. It's miseria.
Na law obia bisa question be say enam sa article 146 no bibia ebetimi remove the number 3 of the state, the powerful person, most powerful person of the state, you know. Senka yetiwi line that's all ultiminka argument ba kwa nkofo ye ne say article 146 no enam say express a process say betimi dey remove chief justice away the number 3 most powerful person of the state, you know. Enka yenya LIB an legal instrument be a bit guide the oppressor or institute sa processes no. It sounds whereby a nipano when you're a legal officer. And what argument to saying?
So first of all, 146 article 146 can ye a war head note no depending on your constitution. Can head note no.
Bacho meba. Article 146, okay. But you're saying that it's
head note.
Head note in Pacho mechanics here, Pacho. Article 146. Or say head note and say removal of justices of superior courts and chairman of tribunals.
So chairman of
regional tribunals.
Good. One with chief justice for her.
Pacho there be.
So the article is about removal of justices of the Superior Court of Judicature and regional tribunal.
And chairman of regional tribunals. Oh, yeah.
Yes. Now, Article 146 lays out a procedure for the removal of this category of people. Now, if it is a justice of the Superior Court of Judicature or a chairman of a regional tribunal, a petition by a citizen of Ghana, you're the coin.
You're the president.
You're the president, not president.
Council of State.
No.
My main council.
That president, I am my chief justice.
Chief justice.
Not chief justice, I determine the prima facie.
Sure.
But so. Say petition a removal of a chief justice. Won't even find come chief justice. Anna
there be a fano.
So that another principle of law will come into play. She can be a judge in her own cause. Into the 1969 constitution to say if it involves the removal of a chief justice, President Enfa petition no Enco Council of State, and in consultation with Council of State, determined prima facie. So it's a procedure, it's a procedural limitation on the exercise of power of the president.
Okay.
That's one thing you must understand. But the second leg, because in 2011, Attorney's Ethics Constitutional Review Committee, Constitutional Review Committee, no, recommendation 220, almost say the rules of court committee and developing processes and procedures for the removal of a chief justice under Article 146.
Exactly.
So many we are doing.
Baba, ba nkrofo so aye say section 297H, that is subclause 8H of the Constitution, you know, was it was directing or empowering a public officer to do any act or thing, or otherwise applying to him by the designation of his office, include his successors in office and all his deputies and all other assistants. Enti nipa bi kwa kan say maami na sam ye gina article 146 so it must be read in tandem with the 297H of the Constitution. I had to say,
oh, the Article 296, Article 297 doesn't apply here. Article 296 is a self-contained provision.
Yeah, sure.
It's a self-contained provision. Indeed, those who are arguing that we are straining the Constitution. When you read Article 296, you will perfectly understand what is intended in the remit. You don't need to go back to other areas to understand Article 296. Okay. And in all decisions of the court, in particular Ajechum and Attorney General, it was clear that Article 146 is very, very clear. The only reading into Article 146 was the establishment of prima facie, and it flew from it arises out of the Article 146(1) of the Constitution. Oh, okay. The Chief Justice, or Justice of the Superior Court of Judicature. So until we see Justices of the Superior Court of Judicature, there must be a determination of prima facie. It also applies to the Chief Justice because also a Justice of the Superior Court of Judicature. Sure. Papa, so I don't know where people are reading that. It's very interesting. Will be a raising point to be said. Now, she's no more Chief Justice of the Republic, but still Justice of the Supreme Court. Sanity. No, yes, sir. The Chief Justice because we are Justice of the Superior Court of Judicature. Chief Justice is because he's Justice of the Superior Court of Judicature. Wouldn't mean and a Supreme Court judge. Wouldn't mean and as Justice of the Superior Court of as a Chief Justice without necessarily removing me as Justice of the Superior Court of Judicature. You can't. Oh, okay. Because who can head note? Head note to say removal of Justices of the Superior Court of Judicature. And cast a removal of Chief Justice. Yeah. So you have to read it as a whole, holistically. Holistically. Papanti said Constitutional Review Committee report to Professor pencil or de buy out no or recommend they say yenya procedural AEB attach 146 no. Ebra so say Parliament itimi pega no ho say yebetumi aye saade to forestall any recurrence. Parliament impo. Okay. Instrument is in Parliament. Okay. And yet, what you better say, pa now, Sabre Mammy, you remove ni emoluments, no near the idea no abono. No, entitled. Wow. No. Now, only avenue be to appeal against the decision of the president, Anna. Any day. Sebia. They say we need any avenue to appeal against the decision. It's finished.
It is finished.
The Constitution did not intend that the process under Article 146 will be subject to appeal.
Okay, Constitution and Kasa. Mate. Alayi, yebeda sepa.
Okay.
Yes, that's say. Honorable Inusah Fuseini, a former MP for Tamale Central. Now I am nim kese na oye teacher. Inti dia na yetade friend wo ho ye teacher Inusah. Yeah.
OKFM 101.7.